All right, to prove the crime of vessel homicide, which is 7.9.
So with vessel homicide, this will be a bit simpler because we did not propose any changes to the pattern, but we have proposed supplemental instruction.
Right, which I would consider as requested for special instruction. So the question is going to be back to whether the standard instruction sufficiently defines, is sufficient in its language and correct, and the standard adequately conveys the theory of defense. So, let's go ahead and look at it. I don't think you were proposing that I include a citation to the Lizardo case.
Correct.
You just put that in there for my information.
It happens to be in the pattern itself, by coincidence.
Yeah, no, it is.
I don't think the jury's ever heard of the case, so I don't think it matters.
All right, so let's state, why don't you pull up, please, if you would, the defense request after the definition of operate. There's a request for, let's see, there's about 2 pages of special instruction.
Well, I think they're great defense arguments, but I don't think that they should be given under the Stevens case because the actual standard definition is very clear about what recklessness is. The reckless requires the state to prove more than a failure to use ordinary care. It means in a willful or wanton disregard for the safety of persons or property, and then both willful and wanton are defined. And it just seems to me that what the defense has done is just taken a lot of different ways to try to, I don't know, put into jury instructions things which should be arguments. What should be the jury instructions is what adheres to the actual statutory definition. The way that case law has been decided or the way that judges have written certain appellate opinions does not transform those into instructions that should be given.
Okay. Do you have anything you want to tell me? I mean, I've read, you further define in terms of argument also citing to an 11th Circuit case and Black's Law Dictionary what reckless means. And then the next paragraph is, a request, I guess, in instructing the jury for me to elaborate on what the jurors' responsibilities are. You have anything you want to say about either of those paragraphs?
Nothing additional.
Okay, all right. I'm going to decline to include the special request, but they are included as part of the record in your special requested instruction. Do you have you should have a clean copy and include that in part of the record.
So today we will file what we email to you so that everybody's operating under the same paper.
And then on Monday morning, just make a reminder that, just for purposes of the record, that your requested instructions are documented and included in the record, but they're not anything for the jury.
Understood.
Okay. Let's go to the next page, if you would, where there's further request for the court to further define what is sufficient for the state to be able to sustain a conviction for vessel homicide. Again, that first paragraph, I see this as, and again, you're giving me the citations to cases. It wouldn't be part of the request, but further explanation in the instructions, and I am going to find that the instruction given as the standard instructions are sufficient and sufficiently define what elements the jury would have to find for them to come to a conclusion that Mr. Pino was guilty of vessel homicide. And a lot of this I find to be argument, and certainly you can make these arguments, but I'm going to decline to give that as well, and we'll include that as part of the your special requested instructions.
May I turn the court's attention to just a couple more that are in here that I'd like the court to give additional attention to.
Sure.
So you just reviewed the page that begins with this sentence, neither carelessness nor ordinary negligence.
Correct.
That cites to Lizardo, it cites to Warehan, W-E-R-H-A-N, and it cites to Esposito, and I understand the court's overruled our request. Then the next one I'd like the court to look at with additional attention is the citation is Strakar versus State, where it reads, the state must prove that George Pino, quote, in an intentional, knowing, and purposeful manner was operating the vessel at the time of the incident in a manner demonstrating a conscious and intentional indifference to consequences and with knowledge that damage is likely to be done to persons or property. I'd also like the court to consider the instruction that we took from Santisteban versus State, S-A-N-T-I-S-T-E-B-A-N. And this one says, speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive. Let me stop there, Judge, because that's an important issue for this case, since the state is focusing on speed and there is no speed limit posted. We would argue that it creates a bit of a vagueness problem, not a bit, a serious vagueness problem for the operator of a vessel, because speed now becomes at the discretion of the law enforcement officer or the prosecutor handling the case as to what they personally think the speed limit should be under a particular condition. And the jury needs to know it's not even enough that the speed might be deemed excessive. Under those cases, it has to be grossly excessive.
Well, let me ask you, sorry to interrupt, how you, doesn't it depend again on the circumstances of what could be a grossly excessive speed under the circumstances?
Yeah.
Because a speed of 20 miles per hour under certain conditions could be considered grossly excessive under those circumstances. A speed of 80 miles an hour under the totality of the circumstances may not be considered grossly excessive. Does that make sense?
I agree with you. That's why the jury needs to know the speed has to be not just excessive, it has to be grossly excessive.
No, but I'm still using the word grossly. It could be grossly at 30 miles an hour, depending on the circumstances, the additional circumstances. I mean,
that's
would
fine.
you agree with that?
If you feel that it would be helpful to add that speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive under the circumstances,
Yeah.
I'm okay with that.
Okay, I'm not inclined to do that.
Oh.
I just brought it up for, our discussion.
Right. And the reason I'm addressing it is because the state is arguing the speed was excessive. The rule that was presented to the jury, the safe speed rule, implies that there is a particular threshold for safe speed above which a speed would be excessive. And yet that's still not enough to convict under the case law. It would have to be grossly excessive.
Okay.
And the jury needs to know excessive speed alone is not enough. It's got to be grossly excessive. And because there is no posted speed limit or any legislative finding on what is an appropriate speed, we're now turning this over to 6 people to decide what an appropriate speed would have been. But they need to know it's not enough that it's an inappropriate speed. It needs to be grossly excessive. Lizardo was the case where the driver was doing 83.9 miles down, I think, Calle Ocho, and that didn't give the driver enough time to avoid colliding with a car. And the court said even that speed, which was, I forget, 30-something miles above the speed limit, did not support a finding of vehicular homicide. So that's why we need to make sure the jury understands the speed by law needs to be grossly excessive to support a conviction.
Okay. Do you have anything you want to respond to?
Of course, I object to that. I don't think that that is a proper statement of the law because, first off, Lizardo just said on these particular facts, and there weren't many facts other than there was only the speeding. We have a lot more than that here. And beyond that, the definitions of wanton and willful more than sufficiently cover the concepts that defense counsel is trying to somehow, have this court instruct the jury. The jury is the one that's supposed to decide.
And I'm going to decline the request, to look at, speed, the weather conditions, this, that, the other thing. I don't think it's appropriate for me to include that as part of what would be the standard instructions. I think the instructions is given properly define what the law is, and this is part of argument. So while I understand why you're requesting it, I'm going to decline to give that. And also there's something about, I think the next paragraph as well.
So the next
alcohol.
The next paragraph, we just took a direct quote from a case. What we would like is either just an instruction that consumption of alcohol, absent impairment, does not constitute recklessness or culpable negligence. That's what we're requesting. Because obviously the state is presenting evidence of the 2 beers, and I assume they'll be arguing that that somehow is relevant to the analysis of recklessness and or culpable negligence. I think the jury's entitled to know that the courts of appeals, they don't need to know it came from there, but that the law allows alcohol to be consumed, and that the mere consumption of the alcohol, absent some impairment, does not establish recklessness or culpable negligence.
Okay. Anything to respond to?
I would object.
Okay. I am going to decline to give the special requested instruction, but again, it's included as part of the record. Okay. And I think that would, looking at simple inattentiveness, citing to the Esposito case, I think that was your next request.
That's right. So, inattentiveness is insufficient to establish reckless driving. That's what we're asking for. That is what we believe the state is going to argue caused the accident. Mr. Pino was not paying attention in those last 9 seconds as the vessel was approaching and then ultimately collided with the marker. And just as a small footnote, we were talking earlier, you were asking about how the boat with 9 seconds to impact made that veer southbound. 9 seconds later there was the impact, but roughly 1 second before impact there was another apparently data point drop. I believe the expert, Mr. Albert, said that there was some effort there was a change of course, that apparently the inference would be that Mr. Pino, with a second to go, realized the marker was there, tried to take evasive action, and was unable to avoid the marker. That's what I understood him to say.
Okay.
And so it's clear to me that the state's theory is that Mr. Pino was inattentive in the last 9 seconds. And the case law seems to be clear that lack of attention in and of itself is not sufficient to establish recklessness, much less culpable negligence. And so we'd like the court to instruct on that. It comes right from the case law, and so we would ask that the court give an instruction.
Okay. Do you have any comments on that?
Yes, Judge, I think it's a great argument for counsel to make, but it's not the law that the court should be giving.
Judge, may I ask this? Isn't that what courts of appeals do? They write the law as it applies under facts similar to those that are before the trial courts. And so we know from all the cases, Lozada onward, many courts have said speed alone, unless it's grossly excessive, doesn't support recklessness or gross negligence. Alcohol consumption alone, absent impairment, does not support recklessness or culpable negligence. Mere inattentiveness does not support recklessness or culpable negligence. Those are principles of law. That's what the court is supposed to explain to the jury. How otherwise will they understand what to look for in the evidence, if not by instructing them that the law says those matters of evidence that have been presented to them under the law do not suffice. If you don't tell them that, you're leaving it to lawyers to tell them that. But the courts of appeals have said that when lawyers have tried to argue that, it's led to wrongful convictions. So I'm asking you to instruct the jury to avoid a wrongful conviction, as was the case in these 14 cases plus that we have cited to the court.
Understanding absolutely what your point is, and a number of the cases that are cited go back for many years, right?
That's right.
And so, staying in my lane, I'm not going to include language from beyond the standard instructions for further definition, because that's a different branch of government that's responsible for making those changes. And so in these cases, whatever efforts are made, and you see amendments all the time. I think these issues, again, they're a good argument, and I suspect these are the arguments you're going to make, but I believe that the instructions as they exist sufficiently define what the law is, and those changes should be made, if they should be made at all, not by me. But I understand your point.
And I appreciate that you're willing to have the dialogue. This is why in the 11th Circuit they had to change the instruction, because the standard was inadequate to inform the jury of the law. That's why I believe there were 14 wrongful convictions, because the then instructions were insufficient to guide the jury. Jury instructions come from case law. That's where whoever writes those instructions, they get them from the judges who have ruled on cases.
Sure, and they change, and things change constantly.
And let me reveal my ignorance. Who actually writes the state jury instructions, if I may ask? Is it which branch?
Committees that are designated by the Florida Supreme Court, they promulgate the rules and then the court adopts them.
So it is the judicial branch after all.
Well, it's not actually now. Actually, the Florida Bar, the Florida Supreme Court does not engage in the creation of, make the committee recommendations. It goes through the Florida Bar Committee on jury instructions, and that's how. Yeah.
Well, then more of a reason not to simply accept them as the law, since the Florida Bar doesn't trump Your Honor's road by any standard of imagination. So I urge you to reconsider.
I appreciate that, but I'm gonna decline the invitation. But we'll have a copy of all of this, of course, in the record. And there are not a lot of vessel homicide cases, so don't know where we're gonna go, right?
There's one other instruction that we proposed in this section based on the McCreary Supreme Court of Florida case that says if you find that George Pino is not guilty of vessel homicide, you must also find him not guilty of manslaughter by culpable negligence. It's either should come as a form of an instruction because that is the law. If he's not guilty of vessel homicide, he can't be guilty of the greater offense of culpable negligence.
Well, I want to ask the state about that because, you know, that's a point we had already touched on, and whether or not, you know, there would be potential for an inconsistent verdict.
So what I think the simplest way to do it is that the jury shouldn't even deliberate on manslaughter unless they have first found that he is guilty of reckless driving, i.e. vessel homicide. They don't even get to it. So what I would propose is that the court instruct you first must decide if the state has proven count 2. If they haven't, then you find him not guilty and your deliberations have come to an end. There's nothing
It
to go
sounds
to.
like the instructions in a capital case.
I've never
You
done
know,
one.
if you don't find an aggravator, you're done in terms of in second phase. Jury doesn't find unanimously an aggravator exists in a capital case. They do not proceed and the sentence is life. So I think what you're saying is something similar to that, not in the context of what would be an inconsistent verdict, but how the verdict forms would read. And so I am going to ask the state about that because I was curious about that issue, and when we get to the verdict forms, how they should read.
Judge, there was a case, it's State versus Perez. It's at 718 Southern 2nd, 912. It's a 1998 case out of the 5th District Court of Appeal. And in that case, the defendant was charged with...
You said the 5th District, right?
Yes, Your Honor.
And what year did you say? I'm sorry.
1998.
Thank you.
The defendant had been charged with 1 count of vehicular homicide and 1 count of reckless driving. The state charged them as 2 separate crimes as opposed to vehicular homicide with reckless as the lesser.
Okay.
And in that case, the jury came back guilty on vehicular homicide and not guilty on the reckless driving. And in that case, the court found that that was not an inconsistent...
Well, because they came back on the higher charge.
Right, but they found him not guilty of the lower charge.
Right.
And so the argument was, well, if they didn't find him guilty of reckless driving, then they could not have found him guilty of vehicular homicide.
Okay.
And the appellate court in that case said that, in point of fact, these are not truly inconsistent verdicts because there can always be the possibility that the jury just decided to agree on some kind of jury pardon or a compromise type of a verdict. Okay. So I don't think that the claim that the defense is making that if they don't find recklessness, they can't find culpable negligence is not supported by the law.
Well, okay, because is vessel homicide a necessarily lesser included of the manslaughter?
No, it's a category 2, and it depends on how the charges are pled.
Right. Okay. Okay.
And so the state in this case opted not to charge manslaughter with vessel homicide as a lesser. We opted to charge each count by itself.
I see. Okay. All right.
I haven't read the case. We'll read it maybe if we take a few minutes, but I'm guessing that that's a case that deals with the principle of law that on appeal, the courts do not reverse convictions where there appears to have been an inconsistency in the verdict form, and the courts have said they'll ascribe that inconsistency to some jury nullification some other reason other than an actual inconsistency. What we're proposing is to even avoid that possibility. I understand that if it happens, then the defense would lose on appeal on the principle that too bad, so sad. The jury likely just cut your client a break by...
Aren't there different elements, though?
In this case, the theory of prosecution is that the manslaughter was committed with a vessel. So I don't see any other theory of manslaughter other than it was committed, it's vessel homicide plus a greater level of mens rea. That's what the McCreary case said in the Supreme Court of Florida. Specifically said that vehicular, not vessel, but vehicular homicide is a lesser included of manslaughter.
Well, doesn't that go back to the way the state is charged as an alternate theory? It's not just by culpable negligence on the manslaughter?
I don't see why that...
Because McCreary, is it McCreary just a culpable negligence, manslaughter by culpable negligence charge?
So let's assume it was either act or culpable negligence, either 2A or 2C. If it's 2A and it was an intentional act to crash, that would be reckless per se. There'd be no doubt about that, right?
Okay.
If you do it intentionally, it's beyond reckless. So manslaughter, as I have an understanding of it, you've got culpable negligence and then you've got outright intent to... So it's just what they've pled is two different degrees of intent within the manslaughter, both of which are greater than reckless.
Yeah, but why is it not a category 1 lesser?
I don't know. I haven't studied it, but I can.
Okay.
If you give me 5 minutes, I'm sure we can give you the answer.
Because this is going to go to also my verdict forms, our verdict forms, how I think it would be appropriate. And I mean, we have count 1, the manslaughter verdict form, and then we have count 2, the vessel homicide.
I'm sorry. Can you please repeat that?
The verdict forms. I don't have a draft of the verdict forms, but we.
I sent one to the court. I can send one to Norman now.
I'm sorry. Why did I not print them out? Okay.
I'll send them to everybody again.
That's great. Jessica, can you... Where am I finding here? Can you send it to Carolina?
Yes. Yeah, absolutely.
What's that? No, I just need a copy from me. All right. I'm going to pass on the rest of this right now, so we can let's finish up the, what we have in terms of the instructions.
Forgive me, Judge. What are you going to pass on?
I'm going to pass on this question of whether I'm going to consider any addition to the instruction of whether, if the jury finds that Mr. Pino is not guilty of vessel homicide, that